Well, good afternoon, everyone. My name is Catherine Barnard, and I'm delighted to chair the first of the CEL's lunchtime seminars. I'd like to welcome everyone in the room, but also those of you who are online. Today is, of course, a momentous day for the world, and I imagine quite a lot of people were up large parts of the night looking at what happened. It's a momentous day, of course, for the EU and the UK, and the implications of what happened last night will be felt for a number of months to come. But I think one thing we can say is that it's really important that we carry on doing what we do best. And one of the things that we do best is inviting fantastic speakers. And I have a particular interest in this speaker because Barend was one of my fine students, and it's a good example of where a student far exceeds the master. And this is what you will see with Barend's presentation today. So he's going to talk to us about the vexed question of horizontal application and horizontal direct effect. And Barend, the floor is yours. He's going to talk for about 35 minutes. And then I will have time for questions. Anyone who's listening online, I'll monitor the questions online. So please put your questions in and I will read them out. And we will finish by about 5 to 2 so people can get on to their next class. The floor is yours.
Catherine, thank you very much. I'm going to start perhaps with a few words by way of introduction to this topic, because on a day like today in an EU law research seminar, perhaps you would expect to talk about the role of the EU in the world, security, AI, digital technology, and yet I'm here today and I'm going to talk to you about the horizontal direct effect of the free movement provisions, which is really a very old topic that has been discussed and written about for decades. So why am I going to talk to you about this very fundamental and very basic concept? I thought I would start with a bit of a personal anecdote by way of introduction. When I started in Durham, I think about seven years ago, I had to prepare for the new courses I was going to teach. And I opened the textbook written by my new Durham colleague. Catherine, your textbook will follow in a moment, but by Robert Schutze, who's written an EU law textbook. And I opened the textbook and I saw that the Familia Press case was being used as one of the main examples of horizontal direct effect of the free movement provisions. And that came as a bit of a shock to me, an academic. I mean, that's shock is a big word, but an academic shock. Because you know, only a few weeks before, I was still teaching at the University of Groningen, and I'd made this, I thought, very nice problem question for my students based on a Familia Press-like scenario. And I told my students in the feedback session, if you wrote that this was horizontal direct effect, I think you're wrong. I think I said something like, I think you're wrong. This, for me, Familia Press is vertical direct effect. So there was a bit of a dispute in my first few weeks in Durham. Robert and I have continued to talk about this over the years. I think a year later, another colleague, Eleni Franciou, joined Durham. She works on the horizontal effect of fundamental rights, and she was immediately on Robert Schutze's side. So, you know, I was in a minority. I think I'm still in a minority. But by way of starting point, I will say that the 2025 edition of Robert's new textbook will acknowledge that we can have a bit of a debate. So at least I feel, you know, there's been a minor achievement already. But that's the context. I think the context and my sort of fascination with this topic is that, you know, we've been talking about this for decades in EU law. We keep talking about it, but we don't always acknowledge explicitly and openly that we actually sometimes have different conceptualizations, different definitions of the concept of horizontal direct effect. So that's the starting point. I'm going to present in 3 parts. The presentation will have 3 parts. I'm going to start by introducing this dilemma, what I call the Familia Press dilemma, the sort of the case, and these at least two different ways of looking at horizontal direct effect free movement provisions. So that's the dilemma. And the second part will be about why this dilemma is important and why I think it is problematic. That has something to do with the link between direct effect of the free movement provisions and the question of who is responsible for a breach of the free movement provisions, and the question of who is ultimately held liable for a breach of the free movement provisions. So I think one of my arguments is that there is a missing link between this idea of responsibility and liability and direct effect, even though direct effect is usually the first step towards liability for breaches of the free movement provisions. So in the second part, we'll look at this idea of responsibility and why it is important to make a link between the direct effect of the free movement provisions and responsibility. And then in the third part of the presentation, I'm going to talk in a bit more detail about liability. Because if I say that we should improve the link between horizontal direct effect, responsibility and liability, then there's also a responsibility on EU law to improve the liability tools, state liability, horizontal private liability under EU law. So I'll end on with that topic. So let's start with this Familia Press dilemma, and I think a lot of us will know the case. So I'm not going to focus in too much detail on the substance, but I'm going to sort of outline the scenario. This is a slide that I spent a lot of time on in terms of creation. I'm not the most technical, but I hope it's clear. Familia Press was about Austrian law, Austrian legislation, which banned price contests in magazines, or I think probably also in newspapers. I should have checked that. But a general ban on price contests in magazines. And the reason had to do with the protection of press diversity, because if you allow price contests, that could be sort of a tool, I guess, for the wealthier publishers to easily attract readers by offering very generous prizes. And so press diversity was the underlying justification. Bauer, which we see on the right, Bauer was a German publisher who published a magazine with a price contest in it, and they placed it on the Austrian market. They placed it on the Austrian market. They were not chased by the Austrian police or by the Austrian the Austrian Ministry of Culture or Media or something like this. They were chased by a competitor, by an Austrian publisher, Familia Press. So Familia Press brought, I think, what we would call private enforcement action of Austrian law, private enforcement action before the Austrian courts. So this was a horizontal case between two private parties, Familia Press versus Bauer. Familia Press wanted to enforce the legislation, the Austrian legislation against Bauer, and Bauer in their defense said, wait a second, we think that this legislation, that Austrian law, is in breach of the free movement of goods. So Bauer relied on Article 34, or wanted to rely on Article 34 against Familia Press. And so that is the basic scenario. And then, of course, when the case was sent to the Court of Justice, the Austrian state intervened in support of their legislation. So they basically took the side of Familia Press. Now, I guess my first point of surprise and fascination is that when you present this scenario to an EU lawyer, some of us will say that this is horizontal direct effect of the free movement provisions. They will say it is horizontal direct effect of the free movement provisions because Article 34 is applied in a private case, in a case between two private parties. So for that reason, it should be seen as horizontal direct effect. I would call that a procedural approach to direct effect, because the focus is primarily, if not exclusively, on the parties to the case. My approach, a different approach, would be to say, in a case like Familia Press, the free movement challenge, the substance of the challenge is against state legislation. It is against Austrian law. And for that reason, I've always seen Familia Press as a vertical direct effect case. I would call that a substantive approach because it focuses on the question of what is the substance of the measure that is being challenged under the free movement provisions. I think that's my way of starting point. And if you think about these two different approaches, so a procedural approach will say, if the two parties to a case are private, we're talking about horizontal direct effect. A substantive approach will say we need to adopt a slightly more sophisticated perspective. Yes, there is a broader category of horizontal application cases in which the free movement provisions are applied horizontally in a case between two private parties. But in that broader category of horizontal application cases, we need to distinguish between two types of cases. First of all, there's a category of horizontal direct effect cases in which the free movement claim is against private conduct, private rules for which the private party is responsible and should therefore also be held liable. Those are, to me, are the genuine sort of horizontal direct effect cases where the nature of the substance that is being challenged is private, and where the private party or a private party is responsible and should ultimately be held liable. Those cases should be distinguished from what I call horizontal enforcement cases. Horizontal enforcement cases are cases between two private parties. So if you look at the cases, you'll see the two private parties, but the nature of the free movement challenge is against the state, and the state is responsible for the measure that is being challenged. And therefore, I would say the state should also be held liable. So that is the distinction that I make between horizontal direct effect and horizontal enforcement. To be very clear, this is not some sort of nice theoretical academic debate in the corridors of Durham Law School. This distinction has, it has practical consequences, right? In terms of who is ultimately who is ultimately held liable for breaches of the free movement provision. So in terms of the next point of my presentation is then to think a little bit about this link between direct effect, responsibility, and liability. And I think one of the points that I would make is that at the moment, the link between direct effect, responsibility, and liability is not sufficiently anchored, it's not sufficiently reflected in the case law of the Court of Justice. In a case like Familia Press, I think the court was entirely silent on whether this was horizontal or a vertical case. And that can lead to problems with the question of where we ultimately allocate responsibility and liability for free movement cases. In Familia Press was made to defend this Austrian law. You could say, well, actually, Familia Press wasn't forced to enforce Austrian law against Bauer. They voluntarily put on their private police hat in a way, and you see this more regularly in German and Austrian law, private enforcement of the competition provisions, free movement provisions. Quite a few of these free movement cases, the Deutsche Parkinson-Vereinigung, I think was another one. This happens more regularly. But still, private parties should be able to operate, I would say, in a context where they can be confident that the legislative framework which has been set by the state is compatible with the free movement provisions. And I think there's something wrong with a private party being held responsible and liable for breaches of the free movement provisions when they are not, when they aren't responsible for the measure that was being challenged. And in Familia Press, I would say this is clearly, this is a vertical case. It's against the state. In a moment, I'm going to discuss a few cases where that distinction between state responsibility and private responsibility is perhaps a bit more difficult. But one of the practical proposals that I would make for the Court of Justice is to be a bit more explicit about about this link between horizontal direct effect and responsibility and liability. So that in a case like Familia Press, the court would explicitly say, this is a case between two private parties. Article 34 is being enforced horizontally, but it is being enforced against state legislation. For that reason, the state is responsible and the state should ultimately be held liable. So that in a way, the Court of Justice gives a steer in the direction of state responsibility and state liability if the state is in fact responsible. That might not always be very easy. Right? And certainly in terms of the division of tasks between the National Court and the Court of Justice in the preliminary reference procedure, it might not always be very clear cut if the state is responsible or if a private party is responsible. So I'm going to discuss a few cases in a moment where that question of responsibility might be a bit more difficult. But at least it's something that should be addressed by the court, and it should be addressed in this direct effect analysis. And if it's not very clear for the Court of Justice where responsibility should be allocated, then the court should, I would argue, impose joint responsibility and joint liability and send the case back to the National Court to investigate precisely where responsibility should be allocated. So, but this is the starting point for this link between direct effect and responsibility. There are quite a few free movement cases where it's not very clear, who is responsible for the measure that's being challenged. And that's where, in a way, where things get a bit more difficult for my argument, because if you say you need to make a link between direct effect, responsibility, and liability, then how do you decide which party should be held responsible and which party should be held liable? There are today so many different and difficult patterns of interaction between the state and private parties. And it's not always as clear-cut as in Familia Press, I would say, where it is state legislation which is being challenged under the free movement provisions. So I thought I would discuss perhaps 2 out of the 3 cases on the slide, just to give a bit more of an idea of how you allocate responsibility in free movement cases and how you decide who is responsible with this substantive approach to direct effect, who is responsible for the breach of the free movement provisions. And I will start with Frabo. they're all, I think, yeah, the two cases I'll discuss are German cases. Brabo was a case, I think, from about 12 years ago about copper fittings. The facts are not the most entertaining. Copper fittings that connect pieces of water piping, but it's a very technical product, right? It's a very those golden brown copper fittings. If you wanted to place copper fittings on the German market, German law said something like, copper fittings can only be placed on the German market if they comply with the recognized rules of technology, because this is a technologically challenging product. In a way, they have to comply with the rules of technology. And the way to show compliance was to get certification. I think the legislation also imposed the requirement of certification. So you need to go to an external party, to a third party that stamps your product and basically says it's good enough to be placed on the market. I don't think the legislation specified who should do the certification. But in reality, there was only one certification body in Germany, the DVGW. Now, there are too many Germans in the room for me to try and pronounce that. So I'm going to stick to the German certification body, Deutsche Vereinigung des Wasser- und Gasfaches. Yeah, danke sehr. I'll continue in English. The DVGW, and I'll just call it the German certification body. There was only one private German certification body, which effectively had this role of gatekeeper of the German market for copper fittings. Brabo was an Italian manufacturer of copper fittings, an Italian one. They placed their copper fittings on the German market for years. But at some point, the German certification body said, no more, we're not going to certify you anymore, because you have a lab report, a technical report from an Italian lab rather than a German lab. We only accept German lab results. So discrimination, right? I mean, free move of already sounds problematic to a free movement lawyer. There was discrimination on the ground of the nationality of the report. And the question for the court was, does Article 34 apply to the actions of this private certification body? And the court ultimately said yes. I don't think it was very explicit about whether this is horizontal direct effect or vertical direct effect. But if we think about this case from the question of responsibility, I think there are two potential ways of looking at the responsibility question. One way could be to say this German private certification body was operating in a legislative framework which had been set by the state. The state had given this certification body the role of market access gatekeeper or something like this, right? They only had this position of power because of the state legislation. The state is responsible for their regulatory power. In that case, you would probably say this is state responsibility. The state should be held liable. Another way would be to say, actually, if we look at the substance of what is being challenged, the substantive act that is being challenged here is the refusal to recognize the Italian lab report, the discrimination or the refusal to recognize the report. The state had no role to play in that. The state was not involved in the certification activities. So there was they weren't on the board of the certification body. They didn't set the standards. So in terms of the substance of the act, it was very much a private responsibility. The German certification body was responsible for this decision not to recognize the report. So from that perspective, I think for me, ultimately, Frabo is more on the horizontal direct effect side, in the sense that the substance of what was being challenged was the responsibility of the private party itself. And in that sense, I would say this is horizontal direct. We can have a discussion about this later. By way of contrast, we'll skip Laval. Laval has been discussed so many times. It was my first ever academic article was about Laval in the Cambridge Yearbook, explaining why this was horizontal enforcement and why the state should be held responsible. So I'll move on to Allianz, which is a nice contrast also to Frabo. Allianz, again, had a sort of a German component, but it was ultimately about a French manufacturer of breast implants. The PIP factory, I don't know if you remember this, it was a big scandal. Sophie might remember it. It was a big scandal well, not so many years ago, but a French factory that produced breast implants around, in France, but that were distributed around the world. This wasn't sort of a local issue. And they produced them fraudulently. They used cheaper gel than they were supposed to use. So they were acting in breach of the European standards on breast implants. They did this for a long time, so many women received breast implants that were substandard and in breach of EU law, and that were probably more likely to leak. Allianz which is a German insurer, but I think this was about the French subsidiary of the German insurer. Allianz was the French insurer which had concluded a liability insurance policy with the BIP factory. Not voluntarily, because French law imposed an obligation, I think, on manufacturers of medical devices to have liability insurance. And if you couldn't find an insurer, the state would allocate one. So Allianz, and I think this was probably at a time when things were already sort of people already knew that, you know, this factory was a little bit dodgy. No one wanted to insure the BIP factory. Allianz was forced to act as the insurer of the BIP factory under French law. But they were clever. In the policy, they wrote something like, they included a clause that said, this policy only covers damage that has occurred in France. So there was a territorial limitation on a territorial restriction on the coverage of the policy. That policy was then sent to the French state, and they signed it off. So the French authority, the health authority, signed off this contract. So if you think about this from a responsibility, private state responsibility perspective, the clause itself was drafted by a private party, but they sent it to the state, and the state expressly authorized it. So in those circumstances, I would say Allianz is a lot closer to a horizontal enforcement case. It was brought by a German victim. The case was brought by a German victim who wanted to claim damages, but couldn't get it from Allianz because of this territorial limitation, which was potentially problematic from a free movement perspective in terms of the substance. The court in the end said no on that, but from a responsibility point of view, the French state assumed and took responsibility here because they signed off on the substance of the contract. So that's much more like a horizontal enforcement case. So overall, I think if you think about this question of responsibility, and if you adopt this substantive approach to direct effect, it is important to think about the substance and the question of who is responsible for the substance of what is being challenged, the measure that's being challenged under free movement. I'll move on to the next part, which is to make this link from direct effect to responsibility to ultimately liability. Because if my argument is that EU law should care a bit more, or free movement law should care a bit more about this link between responsibility and liability, then we also need to think about what are the liability tools in EU. And again, this goes back to something I think that I discussed earlier already. The EU lawyer's instinct will be to say, you know, these questions of responsibility and liability, they're not part of the preliminary reference procedure. The European Court interprets EU law. The case then gets sent back, and the national court will resolve it. And then we're in the realm, in the scope of procedural autonomy, right? In terms of, so in a way, I think one of my broader points is that we need to think a little bit more about the connections between direct effect, responsibility, and liability, precisely because direct effect, in a way, is such an important connector to responsibility and liability. And if this question of direct effect is a question of EU law, the question of who should be held responsible and who should be held liable should be a question of EU law as well. So we need to look at liability tools. What are the two main liability tools in EU law? State liability and private liability. Those are the two general liability tools. And I'm not going to talk about them in too much detail, but I think I will highlight two issues or two challenges with relying on state liability and private liability as remedies, as EU law remedies, in cases where you want to hold a party liable for a breach of the free movement provisions. Let's first of all think about state liability. If we say that the state is responsible in these horizontal enforcement cases, ultimately the state should be held liable, and the state should pay the bill, in a way, should pay the damages for the breach of the free movement provisions. There is state liability in EU law. There are EU law conditions for state liability: conferral of a right, sufficiently serious breach, and a causal link between the breach and the damage. For private liability, there are no EU-wide conditions, right? We know from a competition law case, from Courage and Crean, that there is this remedy of EU, of horizontal liability in EU law. But unlike for state liability, the court has not laid down these sort of precise conditions for liability. And I'll come to the reasons for that in a moment. When we think about state liability, the sufficiently serious breach threshold and condition is actually, from a practical point of view, I think quite a difficult one if you want to hold the state liable for a breach of the free movement provisions. Because if you think about this, how and where are most free movement cases decided today? They're decided under the proportionality test, right? We go back to Familia Press. The question is this measure, is this ban on price contests suitable to protect press diversity? And even more difficult question is it also necessary to ban price contests to protect press diversity? That is ultimately a balancing test, right? The proportionality test. There's probably certainly when fundamental rights are involved, quite a broad margin of discretion for the for the national authorities to balance those. The sufficiently serious breach, you can only establish a sufficiently serious breach if the state has manifestly disregarded the limits of its discretion. So I think in a lot of these free movement cases, it's actually going to be very difficult to hold the state liable, to make the state pay, if you rely on state liability under EU law, because of this sufficiently serious breach threshold and condition. The second point that I wanted to make is to think about the relationship between state liability and private liability. If you think about the fact that there are no EU conditions for private liability, in practice that makes sense, right? There are good reasons for this, because normally these private liability cases are sorted out in national contract law or national tort law or whatever, restitution or unjust enrichment. We don't need EU law to start to impose EU-wide conditions for private liability. So it makes sense that the court has said, well, from an effectiveness point of view, from the effective functioning of the internal market point of view, we don't need to impose EU-wide conditions for liability. But if you think about this from the question of responsibility, it suddenly means that private parties in most cases can be held liable for breaches of the free movement provisions without a sufficiently serious breach requirement, right? Because in national contract and national tort law, I don't know, I'm not a very serious comparative lawyer, but there isn't necessarily a sufficiently serious breach threshold for a breach of contract or a breach of your duty of care in tort. That sufficiently serious breach threshold has been introduced to protect the state from liability, and in particular legislator. So what that means from the broader perspective of my paper is really that in most circumstances, it's more advantageous for a party, it's easier for a party to bring a case against a private party for a breach of the free movement provisions, because they can't hide behind, or they don't benefit from the protection of this sufficiently serious breach criteria. And that is, again, I think, problematic from this, certainly in cases where the private party, like Familia Press or Allianz, the insurer in the French case, where the private party is not in fact responsible for the measure that has been challenged under the free movement provisions. So I think there's a bit more work to be done for EU law anyway, in terms of developing this remedy for private liability and in thinking about the relationship between state liability and private liability. I think that probably concluded sort of the third part. I'll just do a final slide, just with a little bit of sort of forward thinking. When you walk out of this room and you go back to supervisions or lectures, what do I want you to remember? Anyway, I think the one thing that I would probably like, what I would hope that you remember is the dilemma itself. I think that is probably the main, that was one of the main points, that EU lawyers talk about horizontal direct effect with having these very different definitions or conceptualizations of direct, which have real practical consequences that are not always sufficiently acknowledged. In terms of the way forward for the Court of Justice and for national courts, I think the recognition of the link between direct effect as a first building stone towards responsibility and liability should be improved. So the Court of Justice should include some sort of responsibility analysis in the discussion of direct effect free movement provisions, and it can do so by developing some sort of formulas like the one that I suggested for Familia Press to indicate where the responsibility should be placed. There's also a role for national courts, because I think national courts might have to ask questions in a way that also explicitly asks the Court of Justice to address this question of responsibility. They might not want to, because they might see it as an encroachment on their procedural autonomy, and not just procedural, but on their autonomy to apply the law, the interpretation of the law to the facts of the case. But I hope I've showed in a way sufficiently the connections between between all these different questions between direct effect, responsibility, and liability. Before I finish, one final point. It seemed, I was going to say this at the start, actually. It will be interesting to hear your impressions. My impression from looking at how EU lawyers use horizontal direct effect in textbooks, in articles and in monographs, is that there is a bit of a constitutional law versus private law divide. So I think the constitutional lawyers might be a bit more on the procedural side. So they say, if we have two private parties, if the case is between two private parties and free movement provisions are applied in a case between two private parties, that is horizontal direct effect. I think that tend to be the constitutional lawyers who adopt that position, whilst private lawyers, and I think, Catherine, I was going to ask you this. I think your textbook, I would put it more in the substantive territory. Is that because you are a labor lawyer or you started as a labor lawyer? I don't. I don't know, but there seems to be a bit, and one of the reasons, one of the reasons might be that private lawyers, I guess, are inherently, instinctively a bit more interested in remedies and liability. So that's why they take more of a substantive approach. But it was it's an interesting point to, and I think, the constitutional lawyers are usually in a majority on this point. But it's interesting to discuss it. I think I'm going to stop there. Thank you very much, and I look forward to questions and discussion.